The New York State statutory form recently changed June of last year. So we're not only going to discuss the importance of a power of attorney, I want to also touch on other documents that are called advanced directives, but this highlights kind of the major changes. So we're going to discuss what a power of attorney is, the major changes that just came to this new form, what the provisions on a power of attorney actually mean, and things to kind of look for, because it is always recommended that when you do a power of attorney, which I would say anybody over the age of 18 should do. I have been an attorney in this field now for about 9 years, and a lot of the crisis scenarios that we encounter is when an individual does not have either a validly executed power of attorney, or it may be a valid document, but they didn't understand what certain provisions meant or didn't initial certain places. And unfortunately, that type of omission can drastically reduce really the power of the document and really the purpose of why an individual would do what is called a power of attorney. So part one, what is a power of attorney? So a power of attorney is going to allow you, when you are of sound mind, so you're still confident, you're handling your own financial affairs, you're going to put in writing a person, or it could be more than one, that you want to appoint as what is called your agent. So you as the individual are called the principal, and you're appointing an agent to handle all of your financial affairs. You're doing this document to allow someone else to step into your shoes and basically handle any and all financial affairs. So whether that be paying your bills, calling utility companies, handling deed transfers, signing tax returns. I mean, the great thing in the way we have our power of attorney is it's very broad. It really allows a person to handle what you would do, with the idea being that this agent's going to step into your shoes because you're unable to handle your financial affairs. So if you don't have a power of attorney, or if the power of attorney you've executed is not valid, the individuals, your loved ones, family members, friends, are not going to be able to pay your bills, potentially protect your assets if you need what is called Medicaid, which that is a whole kind of presentation in and of itself to discuss the Medicaid program. And we would need to do what is called an Article 81 guardianship proceeding. So, fortunately, there are statutes and laws that are set up that if someone becomes incapacitated and doesn't have a power of attorney, there's steps that can be taken. A petition is filed with the guardianship part of the Supreme Court in the county of which you are found. So not necessarily where you reside, but if you are, God forbid, let's say in rehab due to a stroke or a surgery in a different county, your family member is going to petition the guardianship part in the county of where you are. That individual who is petitioning is going to have to request court permission to not only find that you are now an incapacitated person, but that they are the appropriate person to be appointed the guardian to handle your property. So your bill paying, asset management, but maybe also medical decisions. So we'll discuss the healthcare proxy, but that is a different type of document that deals with medical. Right now, the main focus in today's program is really on financial, the power of attorney. So Article 81 guardianship is a great tool when we're in that crisis scenario, but it's time consuming. You have attorneys involved, you have legal fees. If you have someone do what's called cross petitioning, it can be very expensive. It can be very chaotic when you have family dynamic issues. So really you alleviate all of that concern and stress by having a simple document called the power of attorney. So there used to be what is called a springing power of attorney. And a lot of times a client will come and ask if we can do what's called the springing, which basically means the power of attorney does not become valid and able to be used until you become incapacitated. It then springs into effect. We don't recommend that type of power of attorney. What is generally used and what is the New York state statutory form is what's called a durable power of attorney. So that document is going to give the access to your agent upon your signing, and we'll go through kind of the requirements. And a lot of times there may be a concern where someone's going to meet with us and say, well, I'm giving all of this power to a person to step into my shoes and do everything I can do. Why would I want to sign that now when I'm handling my own finances? It's a very good question. I mean, first and foremost, you should only be appointing the person as the agent of someone that you trust, because you are giving them great power, but the idea being that they're only going to utilize this power when A, they have the original. So you either maintain the original or you leave it with the attorney. So I'd say maybe 95% of clients choose to leave their original power of attorney in our office. We're not going to release it to the nominated agent unless we get consent from our client or former client, or God forbid they become incapacitated. The agent, meaning the person they've appointed, is contacting us. We're then going to require a doctor letter to confirm that the person is now incapacitated and they now need this power of attorney, the original, to act. So that gives a little bit of comfort to a person, knowing that maybe they're going to keep their original in their own safe and maybe tell a family member where it is, because that leads into the potential issue of now you have the original, you decided to take possession. Where's a safe place to put it? I would not recommend putting it in your safety deposit box, because you don't have signatories on it. And then it's kind of useless in the sense that no one can get into the safety deposit box to be able to get the power of attorney to handle your finances as you've intended. If you put it in your own home, we just want to make sure it doesn't get lost or destroyed. So again, a lot of times the recommendation would be to leave it with the attorney that has prepared it for you, which kind of a side caveat, a question will always be, do I need an attorney to prepare a power of attorney? No, you don't. It's not required by law that you have an attorney prepare the power of attorney. But as we're going to discuss, there's a lot of things to be aware of. And especially now that we've had the substantial change to this New York State statutory form, the change went into effect on June 13th of 2021. So if you printed the old form, which went into effect in 2010, and you signed it on June 14th, you may have had a valid execution. You had a notary, you had witnesses, you signed and initialed in all the right spots, but you're using the old form and therefore it's not valid. So if you were to just Google power of attorney, unfortunately, a lot of different things are going to come up that are not valid. So you want to make sure it's the current form. You don't want to just be printing what kind of looks like a template, because the law requires certain things that we're going to discuss on some of the slides to make sure that this is a valid power of attorney that your agent is going to be able to utilize, is going to be able to go to a bank, and the bank is going to honor that power of attorney so that they can access your assets and affairs. So making sure that a power of attorney is validly executed. There's a lot of citing in here as to the statute. If anybody's curious, we're not going to put it in here and overwhelm you with all the legalese, but it's general obligations law. It goes through the execution requirements as they were currently. It needs to be legible, clear type, size 12 font or higher. It needs to be signed and dated by what's called the principal. So if I'm creating a power of attorney, I would be referenced as the principal in front of a notary. And it used to have what's called the exact wording. So it had to say the front page, caution to the principal and important information for the agent. So again, this was just statutory, very specific language that if a bank looks at your power of attorney and it's not in there, they're not going to honor and or want to discuss this power of attorney any further. Prior to June 13th, 2021, we had what was called the statutory gifts rider. So if you've done a power of attorney and you executed this power of attorney prior to June 13th, 2021, the important thing to look at is whether or not you've initialed, and I think it was section H for Henry, what is the statutory gifts rider. That means that if your agent is acting on your behalf, they not only have the ability to handle your financial affairs, but they can transfer or gift assets out of your name. So again, alarming. Why do you want someone to be able to gift your monies away? But that's not the intent. The intent is if you are now, God forbid, incapacitated, you can't handle your financial affairs, you can't meet with an attorney to do certain planning mechanisms to protect assets and qualify for Medicaid, your power of attorney is going to allow your agent to do that for you. So to briefly get into Medicaid, it's a financial means tested program, meaning that in order to qualify, you must have non-retirement liquid assets below the threshold of $16,800. As we stand today, there is no what we call look back or penalty period to transfer assets and apply for home care community Medicaid. So if you have bank accounts in your name alone, non-retirement, so you have a Chase checking account with $75,000 and you are now incapacitated, so you can't handle your finances, you can't write your own checks, and you are in need of care, no one else, unless you have a power of attorney, is going to be able to get onto the account. Now that let's say you have the valid power of attorney and they're on the account, in order to qualify you for Medicaid, we need to maybe do a prepaid funeral, transfer some assets, do a Medicaid asset protection trust, and that's not going to cause a disqualification. But your agent's only going to be able to do that if prior to June 13th, 2021, you initialed the statutory gifts rider. It's that bracket H, and then there's a full, it was about 4 or 5 page rider that again stated that you as the principal were granting authority to your agent to be able to transfer assets out of your name. So very important, again, if you've executed the power of attorney, to just take a look at it after this presentation, because you're going to have a little bit more of a sense of what to look for other than just, signing in front of a notary, which is important, but there's so many little caveats and places of where to initial that we always want to make sure an individual does. So after June 13th, 2021, the gifting language is now within what's called modifications. So there is no longer a statutory gifts rider. That was to kind of make things easier and so that there was less mistake and or confusion about when someone executed a power of attorney, what type of authority they were giving. We always, again, the person that you are appointing as the agent must be somebody that you trust because you are giving such broad, powerful authority. We're always going to recommend that there is also what's called the successor. So you appoint maybe one person. When you are competent, it makes sense to have an alternate. God forbid something happens to that one person and then you become incapacitated. Well, now there's no one to act on this power of attorney that you took the time to research and do. So the major changes, this is kind of how the power of attorney looks and is today. And if you meet with an attorney, they're going to go through, they're going to have the current statutory form. If you were going to obtain the form yourself, this is kind of the stuff that you want to be aware of. So as I briefly stated, the last revision, so the last form was in 2010. That's when they made substantial changes. That's when we had the statutory gifts rider. It was a very complicated form. You had to initial in multiple places to accomplish the same goal. And this new form that went into effect almost a year ago is meant to simplify and to make it easier for individuals to execute this document properly so that there is not a lot of guardianship proceedings, stress and strife among loved ones when, God forbid, somebody becomes incapacitated. So this is kind of just the little legislative history. We're not going to really go too deep into this, but it basically goes through the chapters of where this power of attorney legislation came in through Governor Cuomo. It was signed by him on March 25th of last year, and again went into effect on June 13th of last year. The major changes, the ones for you guys to really be focused on and to be aware of is that statutory gifts rider. It no longer is this full rider. We no longer require the exact wording in some of the language as long as the wording substantially conforms. But again, that's really not a concern if you're going to be using the New York State statutory form. because that form is going to meet all of these major changes. It's really more a concern if somebody is taking pieces and putting it together themselves. You want to make sure you have all of the right wording. One of the really exciting things for elder law attorneys was number 3, signing requirements. So if we have a client who cannot sign their own name, maybe due to a massive stroke, traumatic brain injury, they're paralyzed. And, we've been creative. You could put a pen in the mouth, pen in the toes, because someone could be mentally competent, but unfortunately, due to maybe ALS or a traumatic brain injury, cannot utilize their hands to initial in all these different spots. And, the old form was, banks were very particular if you went outside of a bracket, not honoring your power of attorney. You can now have an individual sign at your direction. So if I was not incapacitated in the sense mentally, but if I was unable to use my hands to make a mark and or a signature, I can verbalize and or in the way I communicate when I'm of sound mind that someone can sign on my behalf in front of the notary, and that will be accepted. 4, 5, and 6 is really, again, if you're having the New York statutory form signed, is not as much of a concern. It's more on the legal and bank end. The timeline for banks to accept the power of attorney and rely on it, they're trying to make easier, because it was very common for banks to have concerns and reject initially individuals' powers of attorney because it was a liability on them, right? They're saying that because of this form, this third party is able to gift monies, write checks, and they don't want, God forbid, that person's acting improperly to be involved in the mess. So there's now sanctions and damages that can be brought against the bank if they don't honor the power of attorney in a timely manner, given that it is, a validly executed document. We've kind of talked on this, the elimination of the SGR, the statutory gifts rider. That was really the biggest problem with the power of attorney. So if you've done a power of attorney prior to 2021 and you did not initial that statutory gifts rider, I would highly recommend that you meet with an attorney and or have a discussion about executing a new power of attorney so that you can have a very broad form. Unfortunately, it is very common to sit down with a client, and it may be the child or the sibling or the spouse of someone who is now in a nursing home or in rehab. And they'll bring us the power of attorney and say, I can handle all finances. We did this 10 years ago, just in case something happened. And again, with the prior form, nobody explained, or at the time, it just didn't seem of importance of this gifting. And that really drastically changes how we're able to assist someone. I think there's also a lot of misconceptions about what spouses can do on each other's behalf. So if you own property jointly with your spouse, so me and my husband own a home, I don't have automatically the right to sign a deed selling the property on his behalf. We each own 50%. So God forbid I'm incapacitated and we're selling our house. If I don't have a power of attorney, my husband can only sell his 50%. If I don't have a power of attorney or not a valid one, he's going to have to go to court and petition to be my guardian to be able to effectuate that sale. Same thing for retirement accounts. You may have your spouse as the named beneficiary. That really is only coming into a play upon your passing. That doesn't give them any right and or access during a lifetime. So IRAs, retirements, 401ks, 403bs, those are all what we call protected assets from a Medicaid eligibility standpoint, so long as you are taking the required minimum distribution. So once an individual turns 72, they're mandated to take that calculated amount by the IRS. If you're under age 72, there's a way to calculate the amount that you are to withdraw. And now your full principal of that retirement account is protected. It's not going to count towards your Medicaid eligibility. So if we're doing Medicaid and the individual who is ill and needs the care is under 72, they don't have a power of attorney. There's no one who's going to be able to contact the plan administrator to put that IRA or 401k into what we call pay status to take that required distribution. That's going to be a hurdle to them obtaining Medicaid eligibility. So power of attorney really is a great tool to come into play in so many different scenarios. I mean, I really highly recommend anyone over the age of 18. So, we have clients come to us, the child is going to college, right? Now they're going to have a bank account in their name alone. If they want to be able to have their parents assist them, they will do a power of attorney and appoint a parent to be the agent in case something happens and they need their parent, maybe when they're studying abroad, to be able to access their account. So I think it's very common for people to think that you don't necessarily need a power of attorney until much later in life and when you're dealing with discussions about long-term care. But I think it's definitely one of the first documents to be discussed. Last will and testament is usually the first thing people want to ask me about, is that they haven't updated their will, they need a new will, and while that could be important, the power of attorney is really crucial. There's a lot of slides to go through, so I don't really want to harp with you guys on the law and how the wording requirements have changed. I'd be more than happy to circulate the slides after the presentation. But again, if you're going to be meeting with an attorney, this is all, you don't need to worry about all of the wording of the document. What I was discussing with the signing requirements being signed at the direction, the power of attorney is going to require 2 witnesses now. So the good thing is that the notary, who's going to not acknowledge your signature, can also act as one of the witnesses. It's very important to make sure that the 2 witnesses, including the notary, are what we call disinterested. So we can't have the person you appoint as the agent or an immediate family member be the witness. We don't want there to be any impropriety, or if there's ever a question about whether or not the person had the capacity to sign this document, it's always best to have 2 disinterested people be able to say, I was there, I was present, they were of sound mind when they signed this document. Changes to the construction. So again, this is just more nitty-gritty ways that is important to know about how the power of attorney changed, and that we like to include in the presentations, but I don't want to spend too much time going through all of the different sections of the statute. We discussed the timeline for acceptance and reliance. So this was really huge in allowing our clients to be able to deal with financial institutions and get them to honor and accept the power of attorney much quicker. Usually the procedure is that it will go to their legal department, and then the legal department may take a week or 2 to review and honor the power of attorney, and then get back to the agent to say whether or not they're going to accept it. It's going much quicker now, which is great, because again, if someone's now utilizing this power of attorney in a time of crisis, whether it be for Medicaid or someone's in a facility having surgery, we generally don't have all of this wiggle room and flexibility to wait and then have them come back and find some silly reason that they're going to deny the form. So what we have seen and what to continue expecting is that banks may ask the attorney who prepared the power of attorney for kind of what we call an opinion letter. I haven't actually seen it as much as I anticipated with the new changes last June. But basically a bank to give them kind of a sense of confidence that this is a valid power of attorney that was executed properly, and the person, was aware of what it was they were doing and why they chose this individual, may ask the attorney for a letter to demonstrate that. So dealing with these new provisions. So if you were to pull what's called the statutory gifts rider, or the New York State statutory form, my apologies. So if you were to go right now and Google the 2021 New York State statutory form, what used to be the statutory gifts rider, so section H, is now modifications. Modifications on the statutory form is going to tell you that in the section that you can make additional provisions, but then it's going to be blank. So this is very important because there's certain language that should go within the modifications that if it's not there, may later be an issue. So our power of attorney, is the New York State statutory form, and then there's about 6 or 7 pages of very specific authority. I think it goes through the alphabet like A through Z and then AA through MM of authority that can be delineated and given to your agent. And a lot of those will need to deal with the gifting that we used to see in the statutory gifts rider, now is going to be within what we call modifications. So our form is going to demonstrate whether the agent can make gifts to themselves, to another person, if it's limited to certain amounts. The good thing is that modifications kind of allows you as the principal to tailor the power of attorney. You may not feel comfortable making it a broad, my agent can do anything and everything. You may want to tailor it. Some people choose to limit gifting to certain annual exclusions. Some people limit it to an amount that they choose. So yes, it's a statutory form, but modifications is where you can kind of be creative and change a lot of the provisions that you feel comfortable giving to an agent. These are some of the examples of what we have in our power of attorney. So transfers to an UTMA account, 529 accounts, opening, I'm not going to read through all of them, but basically opening new bank accounts, changing beneficiaries, creating, amending, revoking trusts. So really the idea being, and I know I've said it many times, is that the agent you've appointed is able to step into your shoes and basically act on your behalf in your best interests. Drafting consideration. So this really, again, I would prefer and recommend that you meet with an attorney to review your wishes and the control you'd like to give to the agent under your power of attorney. But these are kind of the things to be aware of if you're putting together the form or printing one off of line. You need to expressly state certain things within modifications. So if you want to make gifts in excess of 5,000, you're going to expressly state that. Changing designation of beneficiaries. Again, you're going to want to have that within modifications for your agent to be able to do that. For banking transactions, you'll see the 2 listed here from the statute. If there's anything that can be maybe inconsistent, again, because the old form was very wordy, you want to make sure that the attorney and or the form you're printing doesn't have in one section that, this does not revoke your prior power of attorney, and another say by signing you've revoked all prior powers of attorney. That's, I would say, another just kind of side note when you're creating a new power of attorney. We have some clients who appoint an agent for the sole purpose of maybe going forward with a real estate sale. So they don't want this fully broad power of attorney, but they're not going to be available. So they're doing a power of attorney for real estate transactions. And we want to make sure when they sign this very limited power of attorney that it doesn't revoke any and all prior broad powers of attorney. We don't want to get rid of the authority they've given to a previous agent for the sole purpose of allowing them, flexibility to handle maybe a real estate transaction. The other kind of different thing about the new form is that there are sections that are optional that we can now delete and put in intentionally omitted. So it was very common to be going through the old form with the client at the time of signing, and there were sections such as designation of monitors, which is a third party basically monitoring the transactions of the agent, or compensation of agents that were optional. And 99% of the time, I think there's only, I can count on one hand when somebody appointed a monitor and or compensated their agent, because usually the agent was a spouse or a child. And they didn't want a third party looking at any and all transactions that were occurring or monitoring. And they didn't feel the need to have that loved one being compensated for, being on the bank account. So they'd always ask, well, can't you just delete this? It doesn't apply. And it's adding all this other language when I don't want it. So the old form, we couldn't do it. Now we can. So it kind of cleans it up a little bit, which, kind of the little things that us attorneys get excited about on these new forms. This is also language. So if someone's going to sign at the direction, we want you to have language. So you can't sign, but someone signed for you. And what's called the acknowledgement. So the notary basically confirming that the principal, you were in their presence and the witnesses were present. Again, I'll send the slides, very important things to be aware of. These are some of the resources that, again, you guys will have. If you were curious in the legislation, the statutes, and kind of the review of this new form. So the other recommended, what we call advanced directives, a healthcare proxy. So a healthcare proxy is a form that allows you, again, when you are of sound mind, to appoint another individual to make healthcare decisions for you. So today's presentation really focused on financial, but it's important to also have your discussions with the individuals that you want to make decisions for you if you're unable to about your healthcare. The difference in forms with the healthcare proxy is you can only appoint one person at a time. So I can have my husband make medical decisions if I'm unable to. If not, then maybe my mother. If not, then my father. I can't have everybody acting, simultaneously. On the power of attorney for financial, you can appoint more than one person. You can have 2, 3, I've had clients do 4 people either appointed at the same time to act together, or there's a little bracket that you would initial for those individuals to act separately. So in medical decision making, a doctor is not going to want multiple people involved because that can get very messy. We're going to have one person that you appoint, and it's very important for you to have a conversation with that one person as to all of your wishes. So everything that you would want done, would not want done, because the idea is the proxy is stepping into your shoes for the medical decisions if you're unable to make them for yourself. As an attorney, we do not do the DNR, do not resuscitate. If that's something that someone is interested in, we would recommend you speak with the doctor or medical professional. There's also a form called a MOLST form that doctors can prepare for you. What we can do is what's called a living will. So a living will is referenced kind of as the belts and suspenders to your healthcare proxy, that if you have strong views that you don't want to be kept alive by extraordinary heroic measures if you were in a permanently unconscious vegetative state with no chance of recovery. If that's the conversation that you've had with your proxy, then you would evidence it as well in writing in front of 2 witnesses. So if God forbid your proxy ever had to act and make a decision and have that conversation with the doctor, if the doctor, wants to confirm that you're aware of the wishes, they're going to ask if a living will has been executed. So that generally is something that is accompanied with the proxy that the majority of our clients are going to choose to sign. I don't want to get too off course, but a lot of people, when they ask us about a power of attorney, want to know about last will and testaments. And, again, I'd say the biggest misconception is that the last will and testament is the most important document to execute. A last will and testament is only going to apply upon your passing. And if on your date of death, you had an asset titled to your name alone, with no joint account owner, no named beneficiary. So if I have a Chase bank account with $50,000 in it, and it was in Samantha Lyons' name alone, I did not have anyone else joint with me, and I never filled out beneficiary designations. No one's going to be able to access that account upon my passing. The power of attorney is going to end upon my death. So power of attorney is a great tool, but it's only stretches so far as during your lifetime. I get a lot of calls where people will say, my mother passed and I am her executor. I need to access her monies to pay the funeral. So unfortunately, it's not that simple. You know, you are a nominated executor within a document until that original will has been filed for what we call probate in the surrogate's court. And the surrogate has basically found that will to be valid. And then they issue what's called letters testamentary. That can be a time-consuming process. It can be a few months. So you don't just get access to your loved ones or family members' bank accounts or assets by simply being listed within their last will. So I think that's something that's very important, because until that will is filed with the court and recognized by the surrogate, it just evidences someone's wishes. It doesn't give anybody any authority to do anything. So by doing proper estate planning, either by utilizing the power of attorney if someone's incapacitated to add a joint account owner or to add beneficiary designations, or to do certain forms of trusts. There's the revocable or revocable trust, an irrevocable or irrevocable, which is a Medicaid asset protection trust. Those all avoid probate. So those take assets out of an individual's name alone, and then the individual has kind of control through the beneficiary designations and language within the trust document as to how they want these assets, whether it be real property, vacation property, co-ops, stocks. You know, the great news with the Medicaid asset protection, the irrevocable trust, is that there really is not a limit as to the type of asset they can hold. You know, we have clients assign corporations, LLCs. There's a lot of different mechanisms based on somebody's goals, right? Whether it's to avoid probate, to have for a more efficient, less expensive and private, because filing of your will, it's a public proceeding. Anyone can, you know, review the inventory of assets. That is also a very important discussion. But I still will end the presentation with saying that I think that the power of attorney is really the most important document that if you have not done, that you have a conversation about.